too will present paradoxes and contradictions not easy to resolve, that the use of criminal law to regulate gender, sexuality, and reproduction and international human rights throw up. Aristotle defends justice as treating likes alike and unlikes unlike, formally or substantively. De Gouges claims citizenship and rights, as well as those made by LGBT community today, sex workers, people living with HIV and AIDS, and many women, sound in the same register. Whatever differences might exist are only apparent and not real, and in fact should make no difference in the law. There should be no discrimination and no infringement on liberty unless there is harm to third parties. So there should be no criminalization. This is the classic liberalism, and international human rights has raised, or perhaps inflated, depending on how you think of this, to the claims of global neoliberal universals. What this means is that substantive legal claims about what human rights requires of states are riven with contradiction. Some human rights norms characterize certain sexual, reproductive, and gender-based identities, behavior, and practices as violations and require them to be abolished, banned, criminalized, as if they were established in jus cogens. Conversely, the criminalization of those same behaviors and practices are held out by other human rights norms, themselves as violations, the remedy for which should be decriminalization and legalization. And this carries into advocacy within and across sexual, reproductive, and women's rights NGOs, where there is incoherence, unintended consequences, and missed opportunities for the advancement of rights. My colleague, Alice Miller, who's at Yale Law School, and I, we've written on this topic in other places, and we decided to organize an international interdisciplinary project and an edited book to breathe some air and hopefully some light into what seemed like this contradiction. Is this a contradiction that's simply apparent? How and why do these antithetical positions develop? When and where? Does this suggest that the Human Rights Project is for naught or merely fraught? Can anything productive be salvaged substantively for human rights law and as guidance for advocacy from such a study? So in the rest of my talk, which draws from the book's introduction and is very much a work in progress and is very muddled and repetitive and a bit confused, so you are my guinea pigs here, I will situate our project and describe the conceptual terrain, and then I will touch briefly on my research regarding the criminalization of abortion, and end with a prescription or suggestions for some productive ways to resolve the contradiction, or at least live it. So here's the paper. Here I want to give you a snapshot of the development of criminal law in the area of sex, gender, and reproductive regulation in the context of human rights at the national and international level recently. In 2004, a number of West African nations met in N'Djamena, Chad, to develop model legislation to address a persistent HIV epidemic. Articles 1 and 36 of this model law called for nations to criminalize the intentional transmission of HIV. Women's rights advocates were on both sides of this appeal. Some were convinced that the criminal law should give them leverage over their philandering partners. Others considered that the criminal law would only stigmatize and disempower women. This was particularly acute in Sierra Leone, where a prosecutor had said, yes, in fact, this model law could be used to criminalize and prosecute women who gave birth to babies who had HIV. That in the process of birth, they will have intentionally transmitted HIV to their children. And that seemed like quite an unjust outcome. And as a result, Sierra Leone did not pass this model law. Countries across the political spectrum criminalize HIV transmission, however. Canada is at the forefront of nations that criminally prosecute the intentional transmission of HIV, and Uganda joined the ranks in 2014. So politically, right, you have very different compositions of governments that have adopted this as a norm. In international and national settings, harsh criminal penalties are invoked simultaneously to defend traditional values as well as promote modern human rights. These diverse impulses are visible in the recent calls to impose a death penalty for homosexuality in Uganda and elsewhere, and conversely, in the United States, persons who kill homosexuals. Now, it hasn't passed, but hate crime legislation was proposed in a number of states in the United States that would have allowed for the death penalty to be imposed. Draconian practices, draconian detention practices, and dubious criminal justice procedures trail avowedly progressive impulses to punish in the service of some higher ethic, as in the calls to globally to end impunity through the prosecution of rapists in the contexts as diverse as the conflicts in Eastern Congo, DRC, and in ex-Yugoslavia, and in response to the recent rapes in India. In fact, that international calls to punish rape are part of an international human rights regime that explicitly excludes capital punishments seems lost in the call by some feminist groups to execute rapists at the national level. Sometimes the liberalization of criminal law in the name of rights is offset elsewhere, as in the penal code, such as in Nicaragua, where abortion was criminalized absolutely at the same time homosexuality and any criminal penalties for that were liberalized. Prostitution is yet another contradictory site for the criminal law and rights claims. Historically, in many countries, prostitution law served to punish sex enacted merely to gratify the passions of another. It marked women mostly as tainted vectors of lust and disease. Now prostitution laws have been revised with a new claim for women's rights, albeit through prostitution's conflation with the definition of criminal trafficking in persons. This is under the 2000 Palermo Protocol to the UN Convention on Transnational Crime. These rights advocates claim to protect autonomy by criminalizing the sale of sex. This is in direct tensions with claims by some human rights advocates that sexual autonomy is best protected by decriminalizing the sale of sex. Canada right now is in the midst of a fierce fight over the appropriate direction to reform its criminal law after its constitutional court struck down key aspects of a law that regulated the sale of sex on the grounds that the law itself violated the rights of sex workers. So it had prohibited the sale of sex in the streets and some other things, and the Supreme Court of Canada struck down the law. And as you know, contestations continue to erupt north and south, whether over prosecutions for FGM or headscarves. But these are just some examples, and they continue to proliferate. I can't even speak. Now, these issues, especially the suppression and penalization of them, cohere for those who see them as an outgrowth of the natural, biological, if not divinely ordained sex differences, which give rise to gender and the social organization of production and reproduction of our lives, and so on. Writes my colleague at the University of Chicago Law School, Marianne Case, quote, "For the last several decades, the English word gender has been anathema to the Vatican and those seeking to influence secular law and policy through the world on its behalf. The Vatican sees and assumes its opponents also see a tight connection between and among all the components it incorporates under the, quote, gender agenda, such as the dismantling of sex roles, the acceptance of homosexuality, the recognition of a diversity of family forms and of sexual and gender expression, and access to new reproductive technologies, condoms, other contraceptives, and abortion. In short, most of what goes under the diverse headings as women's sexual and reproductive rights, sexual orientation and gender identity, family law reform, and the elimination of sex stereotypings." And I note it's not only the Vatican, but many other religions, evangelical Protestantism, Orthodox Christianity, varieties of Islam, not uniformly. There are many also contestations, but generally these are the areas where the most coherent and vociferous criticisms from the expansion of rights come from. And from the human rights perspective, however, sexuality, gender, and reproduction are often siloed from the point, or separated from the points of view of legal classification and rights advocacy. Sexuality and human rights work tends towards issues relating to sexual orientation, sex work, sexual exploitation, and HIV transmission. Gender rights get amalgamated with women's equality and discrimination, including gender-based and sexual violence. And reproduction is often reduced to abortion, although it sometimes includes contraception, assisted reproductive technologies, gestational surrogacy, as well as maternal mortality reduction. And although the same human rights to privacy, non-discrimination, health, freedom from torture, and other bodily integrity rights are marshaled to support advocacy in each domain, the actual practice and development of human rights in these areas is greatly disconnected. For example, when gay rights advocates freely ask whether their efforts to decriminalize same-sex behavior need to be linked to the less successful ones to decriminalize heterosexual women's rights to sex without penalty, either in regard to the criminalization of abortion or to fornication or marital rape laws. Yet, as what Marianne Case notes, what connects these issues are underlying logics and assumptions regarding sex-gender systems and their hierarchical ordering, so that procreative heterosexual monogamy is what is protected, and non-procreative, sometimes same-sex sexual acts for money or with objects, or you name it, become less and less and less protected by law. Therefore, these issues are held together discursively in an attempt to establish gender normativity from its deviance. This mutually constitutive terrain is where biological and socially constructed difference takes on salience and remains bitterly contested. Not because this ever has been so, but precisely because the global neoliberal decades we are living through and the newly established institutions within human rights have now created the ground to resist them. And this is sort of the thesis of the book and of the introduction, that it's actually not because these kinds of differences have been established in religion and traditionally protected, but rather it's very much a question of modern politics and resistance to what's going on internationally in the evolution of human rights norms. And I guess the question I have for you, who are international human rights students and future professors, as well as advocates and lawyers, is what do you think? Is this inevitable, this kind of contestation? Is this productive? Are there ways around it? What to do, basically? Love to know your thoughts. So we see this in the criminal law turn that marks the transformation of the relationship of international human rights to criminal law, as well as the contestation of state power in defining the secular and the limits of tolerance by criminalizing non-conforming gendered and sexual practices. So I'm going to start a little with the latter. The regulation through criminal and other bodies of law of sex-gendered reproduction by the state is nothing new. Abortion, homosexuality, prostitution, along with adultery, sodomy, incest, bigamy, polygamy, bestiality, pederasty, apostasy, and blasphemy, and name your knees, have all been regulated by criminal law, often classified as vice in common law, continental legal systems, as well as other legal regimes. That this vice classification is a legacy from certain ecclesiastic traditions, that is to say, Christian church doctrine, is undeniable. What was a sin became a crime, and certain religious crimes of superstition were purged from Enlightenment-inspired legal reform codes to some extent, say in the Code Pénal. But, even there you see a gender double standard persist over the years. Islam, Hinduism, Confucianism inflect the criminal codes of the countries in which they predominate as well. But in each case, religion alone does not explain the content or the operation of the law. Context is all important. National histories, contemporary regional and global politics produce radical differences in substance and implementation of the crimes. And much of the research project that Ali and I have been overseeing has commissioned many country case studies. Some are historical, some are more current, that demonstrate these differences. And in the paper I list a few. I'm going to skip over them just for time, but I'm happy to come back to them. But you see it in Lebanon, in Brazil, in Korea, in the United States, across Europe, very contextualized differences in the way in which different laws are, or different movements try to promote the criminalization or the decriminalization of different aspects of this range of what were formerly understood as vice. To sum up the case studies, what we see is that with the rise of self-proclaimed liberal and secular nation-states in the West and the North, and the exportation of its criminal codes to the colonies, and their adoption as authentic by post-colonial states, secularity has had a very uneven track record in regard to loosening and now tightening some gender and sex regulation. In many states, secularism has removed some practices from penal oversight, say fornication or adultery, and invented or increased penalization of other practices, rape or child sexual abuse. The expansions and contractions in the scope of who is or who is no longer vulnerable to the criminal law is gendered, but not symmetrically or balanced within a gender or easily mapped. So just so I can't be accused of focusing solely on women, the criminal law also constitutes men as a category that is both more or less vulnerable. Less vulnerable when same-sex behavior between men is decriminalized, or more vulnerable as both heterosexual and homosexual men when rape in marriage is made a crime, or the so-called age of consent is raised. These expansions and contractions in contemporary settings are closely linked to the dynamism of emerging human rights claims and other underlying political, cultural, and material conditions that are also often reactionary. A review of the rationales for the criminality of sexual and gender practices, though, begs the question: what permits states today, nearly all of which have ratified at least one international human rights treaty, to now criminalize abortion, homosexuality, HIV transmission, and sex work? Is it just? Is this the question? What motives justify punishment by the state, which most vexes? Oh, this is the question. What motives justify punishment by the state, which most vexes human rights engaging with criminal law? Insofar as I'm an Anglo-Saxon trained human rights jurist, we often refer to the harm principle articulated by Jeremy Bentham and J.S. Mill, Enlightenment penal reformers and classic liberal theorists, and what I referred to briefly in the introduction. Writes Mill, quote, that the only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. So harm to third parties is the only justifiable basis for restricting liberty. Who is that third party here? This is what the current contested terrain is. The justifications for the use of the criminal law to regulate the private, consensual behavior of adults lost traction during the mid-20th century. In 1955, a U.S. law professor named Herbert Weschler led a prominent model penal code commission in drafting a report that for the first time omitted sodomy. I know that France has a different tradition. Stating that, quote, no harm to the secular interests of the community is involved in atypical sex practice in private between consenting adult partners. This area of private morals is the distinctive concern of spiritual authorities. In 1957, England's Wolfenden Commission made headlines by proposing to repeal criminal bans on sodomy as infringing on sexual relations that were properly private. In the ensuing debate over the Commission's report, Lord Patrick Devlin defended the use of the criminal law to enforce public morals, while H.L.A. Hart countered by emphasizing the importance of protecting the sphere of liberty, of individual privacy from the reach of the criminal law. Vice or moral crimes were considered victimless crimes. This idea is more or less incorporated into modern legal thought in liberal democracies And generally we see these ideas around consent and privacy in the principles that are incorporated into international human rights law. But here's the rub. The harm principle, meant to limit the scope and application of criminal law, is more recently thought to be the very purpose of the imposition of criminal law and its penalties. Douglas Husak, a philosopher of criminal law, and Bernard Harcourt, a professor of law at the University of Chicago, recognize this point. Criminal law is meant to stigmatize the person, and the penal incarceration to remove and exclude the offender from the benefit of society. This gives much actual and symbolic power to those who would wield the criminal code, and it's quite seductive to those who rule, seek, or need to consolidate their rule, and I'll talk about this more in a moment, but it goes to the politics. Furthermore, those who seek to make an act criminal or liberate it from its criminal code also mobilize the language of harm. For those who wish to criminally prohibit sex work, for example, they use arguments that sex work exploits those who sell sex, or profit from its sale, that it degrades women or destroys the family. The criminal law works because it both prevents and remedies the harm to victims and society, as well as it extracts its toll from the appropriate parties, the malevolent actors. This argument, though, is indeterminate, and it can be expanded to anything, to abortion. Criminal laws on abortion protect the fetus from harm, and they protect the institution of motherhood, or same-sex practices, although it's hard to find arguments on the side of who same-sex practices possibly harm, but in the US we hear that they harm the children, or that in fact they can't be consensual, or that, you know, the institution of the family is harmed. The intentional transmission of HIV, it harms sexual partners, and so on. And conversely, for those who resist sex work prohibitions, the harm that the application of the criminal law itself causes is the problem. Criminal law stigmatizes sex workers and allows for more exploitation and harm by law enforcement officials who themselves are corrupt. So harm is arguable on both sides, and we're not sure it will establish a bright line, a no. Nor do we think consent, which is another point of reference for these arguments, is a magic bullet, because one cannot consent to become a victim of a crime, so it becomes circular in terms of a rationale for using the criminal law. But this again is paradoxical, because as I referred to before, the actual pain and the expressive symbolic work of exclusion by criminal law makes calls to criminalize whatever it is, fill in the blank, the very low-hanging fruit of populist rule. It authorizes a politics of distraction and moral panic that perennially makes gender nonconformists into outlaws. And it ought to make human rights, especially feminist and sexual rights advocates, cautious in viewing the criminal code as an ally. But not all feminist or sexual rights advocates have these ideas in mind, or necessarily progressive projects. Which brings me to the next point, the criminal turn in international human rights law. How did human rights get to be part of this paradox and an ally of the criminal law? Many claims in the initial post-World War II human rights period focused on rights as a defense against state power. The criminal law, part of the monopoly on the use of force held by the state, was viewed skeptically by international human rights as the movement symbolized by Amnesty International focused first on the abuse of the administration of criminal justice, prisoners of conscience at first, then the death penalty, then torture. However, using prosecution under national and international criminal law to end impunity for human rights violations has arisen most strongly in the global human rights movement since the 1990s. As a result of this emerging field of transitional justice, rights advocates in post-dictatorship democracies often prioritize the role of prosecution for past violations as fundamental to establishing stable, rights-based societies. In the same time period, women's rights activists pushed human rights doctrine to engage with criminal prosecution in order to protect gender equality and security of the person, and to end the state's silence over violations of women's basic human rights. transitional justice and women's rights claims in human rights then jointly expanded to the domain of international criminal law and the various criminal tribunals. These interventions resulted, for example, in the prosecution of sexual violence as a crime against humanity and an element of genocide. Women's rights advocacy also influenced the adoption of an international criminal protocol against human trafficking in the context of the rapidly expanding field of international criminal law more generally. Most recently, scholarships and advocacy highlighting the injustice of failing to include the rape of men in penal codes has resulted in a highly contentious struggle over making rape laws gender neutral, a move which at a minimum would expand the scope of rape prosecutions for victims and possible perpetrators. It's not universally about women. Thus, criminal law has become not only a standard tool of policies for states, but for human rights as a remedy for violations. Now, for dominance, governance, feminists, in the writings of my colleague Janet Haley and others, the carceral power of the state to punish aberrant masculinity comes not only at a cost, but constructs women as eternal victims in need of protection. This in turn opens up the door to certain regressive political tendencies, reaction to globalization and the neoliberal spread of human rights, that mobilize religion and tradition to reestablish a kind of heterogender normativity that support the kinds of masculinities that dominance feminists themselves would like to lock up. So just to give you a synopsis of this piece of the argument. In general, criminal law can be used only if there's harm to a third party. Those who wish to use the criminal law say, okay, harm to third parties. But who are the third parties here? Is it the state that's harmed? Is it tradition? Is it religion? Is it the vulnerable, such as children? Is it more abstract institutions like the sanctity of marriage? And so on. Those who would resist criminal law say, okay, not only are there no third-party harms, but the criminal law itself harms the populations we seek to protect, who themselves are made more vulnerable by the application of criminal law. And they'll mobilize a lot of empirical evidence, and that itself is a site which there's a lot of contestation. And there are big questions that certainly we talk a lot about in our seminars. How good is the social science data? What happens if the social science data that is showing the criminal law harms actually shows that the criminal law is doing nothing? How do you show over time that the criminal law, which is mostly symbolic and expressive, actually has real social effects? I don't know if many of you have studied social science, but it would be very hard to measure the kind of symbolic effects in real empirical terms. But perhaps you could construct a questionnaire. Then the question is, what's the valid time frame to see that over? Is 1 year enough? Is 3 years enough? Do you need 10 or 20 years? And if we're using criminal law as a tool of social policy, which is very much responsive to election cycles, the time frame that you need to gather good empirical evidence is usually much longer than the time frame of an election cycle. So this whole turn to the empirical validation of the effect of laws is something that's endlessly interesting and has opened up like a new field of study, or renewed this field of study, but itself is a site of contestation. And that brings us back to, finally, the criminal law is supposed to produce harm, whether it's symbolically, so symbolically important and powerful, and it then will attract those who may abuse it, and human rights is both, talks out of both sides of its mouth. Human rights both authorizes and demands that criminal law be a remedy to harm, but because this then invites abuse of power and political opportunism, how can human rights also be used to limit the exercise and the abuse of police power? It gets to be very contradictory. So I'll turn to my own work on the criminalization of abortion to give you an example. I'm going to focus on contemporary abortion bans in Central America, most of which are the result of the influence of the Vatican. and they include explicit agreements, financial and political support by the Catholic Church to the ruling parties. In El Salvador, Nicaragua, in practice, women are imprisoned for 35, 40 years even for infanticide. Often they're first charged with the crime of abortion, which carries a mandatory criminal sentence of 8 years. Fetal autopsy will show that the fetus had air in its lungs, and that charge will then be converted to infanticide. Now, there's much scientific doubt as to the validity of this live birth finding. Often these fetuses could not have survived on their own outside of the womb. And often these women already have children living and dependent on them. So they're put away for 40 years and removed from their family. These stories, there are at least 17 in El Salvador that I studied. They're all tragic, and the verdict's very difficult to overturn. There was a big movement to obtain pardons for the 17 in El Salvador recently that did not succeed. Now, many of these cases show that the distributional effects of these absolute bans, criminal bans, are not born equally. Young, single, poor women disproportionately are affected. And to say that men are not touched would be an overstatement, but it's the women who serve time in jail. These are women who are most likely to come into contact with the state through the public health systems or the criminal justice system, and they're more vulnerable to denunciation by individuals or administration. So those women who live in El Salvador and Nicaragua who can fly to Miami and get a legal abortion already have means. They're not going to go to the public health system. They're not going to be denounced to the prosecutor. This is the hypocrisy of liberalism and a basic contradiction in Marxism, that the law does not apply equally. But I'd like to invoke Foucault here as a theorist of law and power, and particularly criminal law and sexual prohibition. He reminds us that power does not simply repress. It produces and it creates. So what are these absolute criminal prohibitions creating? What are the symbolic effects of these criminal laws? How are they different from the criminal laws that are more or less in compliance with health and human rights? Those that permit abortion if the woman's life is in danger, or for rape or incest, or if fetal anomalies are present. What about their non-application or selective prosecution? Symbolically, these absolute criminal bans construct a complete innocence of the unborn child, empty of all qualities except that the fetus bears absolute rights that are not balanced against any others, such as the life or the health of the woman. The expressive force of the law compels motherhood. All women who have had sexual intercourse, whether consented to or not, who become pregnant, whether the pregnancy is viable or not, are forced to become mothers. Thereby, these bans establish a very narrow gendered norm around female sexual citizenship. They deny females equality, and they establish their inherent criminality when opposed to the inherent innocence of the unborn. The absolute nature of these bans, in contrast to those that allow for exceptions, reflect a politics of purity, much like disease eradication or the abolition of slavery or the abolition of sex trafficking. They speak to a politics of illiberalism rather than one predicated on toleration and compromise, say in a liberal democracy. They mobilize righteousness and fear. I would suggest that these absolute bans are not only about abortion, but they are about distraction and fear-mongering during an election cycle that brings out voters and stirs up emotion, like we saw in Uganda with the anti-homosexuality law, on which elections may hang, which was apparently true both in Nicaragua's 2008 presidential election, which I mentioned before, after which the criminal code was reformed to criminalize abortion, and in El Salvador as well. I would also suggest that many who go along with the absolute criminal ban understand that the law really may not or isn't meant to be implemented. Rather, it sends and expresses a message and creates a climate, drums up and maybe internalizes stigma against a population that is not very well favored anyway. And of course, there really isn't much thought given to those communities against whom the criminal law might be exercised anyway, since they're vulnerable and poor and disfavored and have very little electoral clout. Secondly, these absolute criminal prohibitions do not prohibit, rather they create an alternative economy, an underground one that works outside of and in the shadow of the law, where physicians and others who can provide an abortion can profit and exploit the need and vulnerability of women. even where law enforcement can take a cut. And not to mention that if you have the means, you can avoid the application of the law anyway. I mean, there's some other productive things that the absolute criminalization of abortion law does as well that I'm not going to touch on. But it is out of the insights from like such kind of concrete work, particularly the myriad local political conditions in which and out of which the criminal law is articulated, that we suggest there may be both productive steps to take in relationship to improving advocacy across all these issues that I mentioned, and potentially for generating some substantive human rights coherence that might transcend the particulars of every national case. So for me and for Ali and for many of the researchers, politics is really primary here, and the law is only relatively autonomous from the politics. So what can the content of human rights law do, maybe to constrain the scope of politics, as well as how can we do better advocacy. So I'm going to continue with our two thoughts there. First, to the substance. There is an emerging normative emphasis that the exercise of a human right itself must be legal. The Human Rights Committee's recent General Comment 35 on the right to liberty and security of a person and freedom from arbitrary arrest and detention establishes a very strong limiting principle for criminal law, asserting that the exercise of a right should never be criminalized. Now, this may well work for established civil and political rights, such as political expression, assembly, but it does not seem fully to work yet for those rights, even associated with sexual expression. But it's a place to start within human rights doctrine for articulating some limits on what a state may or may not criminalize. Similarly, arguments have been made that the criminal laws that stigmatize identities, sexuality for example, serve no legitimate state purpose, and that the dismantling of stereotypes and stigma itself is a state obligation under CEDAW, the Convention for the Elimination of All Forms of Discrimination Against Women. There is still much theorizing to do here, especially as occupational identities such as sex work, or transient ones such as pregnancy, do not have the immutable status that most protected categories against discrimination have. But this may also be an argument that could bear fruit. Secondly, in terms of advocacy, we have written elsewhere, and in this project, about the principles of solidarity and accountability. At a minimum, the politics of solidarity is at least rhetorically open to the demands of solidarity. That's to say, if the criminal law is used to express and do X, we need to think about how will it affect Y. To put it bluntly, women's sexual and reproductive rights advocacy needs to be sewn up tighter, with more attention to the consequences of advocating particular remedies may have for other groups. Calls from human rights advocates to expand or strengthen prosecutions for sexual and gender-specific crimes, such as the recognition of marital rape and FGM as crimes, may inadvertently empower a criminal justice sector that is not only ill-equipped, but is often unwilling to respect the rights of those accused of these crimes. Moreover, we know from years of criminological studies that increased criminalization disproportionately and negatively affects society's most marginalized groups, including women, racial and ethnic and other minorities, individuals who do not conform to gender roles and norms, and low-income people. This then leads into the principle of accountability. Human rights practitioners and scholars have had a historic resonance with the distrust of state power and the general principle of non-arbitrary and least restrictive alternative when invoking powers that impact human dignity and rights. In the criminal turn, we need to ensure that the means chosen are effective to the ends stated, and that the stated ends are consistent with the goals of rights, and above all, can be enforced in a non-arbitrary and non-discriminatory manner. Ultimately, international human rights itself is a contradiction. It is a tool of state rule under current international human rights and constitutional norms, and it is a tool of outsider dissent. At any moment, a human rights claim can move from an aspirational challenge to a law-based norm. This is part of the intriguing story of rights engagement with both criminal law and state power in the arena of reproduction, sexuality, and gender. It is elastic and indeterminate. It is redolent of its context. I'll end here with, as promised, no easy resolution, but rather a presentation of this contradiction, which is always good for conversation. Which side of the contradiction are you on? And thank you for your patience. I'm happy to take questions, first of clarification, second of complete and utter opposition, and like, what are you talking about? In English or in French. So thank you.